Welcome back to Questions That Matter. This is a place where we discuss interesting and important research that is being done at TrustBridge. Today, we are going to discuss the issue of debarment and restraint from capital markets. These are sanctions imposed by SEBI. And as with many other sanctions that regulators impose at TrustBridge, we have often wondered what is the process through which some of these sanctions are imposed? What are the reasons the regulator gives for imposing these sanctions? How can we study what is going on with the way these sanctions are imposed? And we have with us Natasha Aggarwal, who, along with Bhavin and myself, did a study on how debarment and restraint from capital markets were imposed by SEBI. So thank you, Natasha, for joining us. Can you tell us a little bit about exactly what the question was and how did you sort of go about trying to gather the data to find out the answers to that question?
So our broad question was, is SEBI providing reasons for imposing the sanctions that it imposes? And the underlying principle of that is that sanctions have immense consequences, right? There's market and reputational risk. So is SEBI giving reasoned orders when it is imposing sanctions? What are the reasons it provides? Are the reasons specific to the types of sanctions that are being imposed, or are they broad reasons which don't tell us anything?
So let me, ask you here. We know, for example, that when penalties have to be imposed, there are provisions in the SEBI Act that say that, the penalty amount has to be proportionate to a few things. I think it's section 15J. And are there similar guardrails in the SEBI Act on how debarment and restraint have to be imposed?
No, there aren't actually. All the SEBI Act says is that there have to be reasons provided in writing, which is not at all specific. There are no guidelines given to SEBI that we know of on when to impose a specific sanction, how long the sanction is going to be for, etc. We see this with a couple of other regulators, so we know that the CCI has something that tells them how to impose certain sanctions, but nothing for SEBI.
But then if I were to play the devil's advocate, right, why should SEBI have, sanctions such as, whether it's debarment or restraint that is proportionate to the offense at hand, right? What should guide SEBI to do that?
So they often, in cases of debarment and restraint, they have tried to calculate the amount of gain that somebody has made because of the violation. So that could be one factor. There could be a question of proportionality to the violation. So is it a repeat violation, similar to what is in section 15J?
Right. And so what did you find?
So we found that, we created a subset of insider trading cases in which debarment and restraint were imposed. And just to put some numbers around this, we found 188 instances of debarment. We found 71 instances of restraint and 57 where both of them had been imposed. Unfortunately, reasons were not really provided in too many of these orders. So in about 19% of the debarment orders, there were no reasons. In about 72% of the restraint orders, there were no reasons. And that's a fairly large and concerning number.
What about the kinds of, were reasons not provided at all, or were they provided but weren't particularly informative?
Yeah, that's a great question, and thank you for making me clarify that. They did provide some reasons, but those reasons were very generic. We see that they use very similar language for all sorts of sanctions. So some of the reasons they provided were, ensuring a level playing field in the market, protecting the interests of investors, thinking through the fact that insider trading is an egregious violation and there must be deterrence, etc., etc. But, we saw these reasons and then we thought, okay, but how much of this is unique to debarment and restraint? And how many of these reasons talk about that specific violation and its proportionality? We used an online tool to compare the reasons for imposing penalties and for imposing debarments. And we found a 99% similarity between the reasons for debarment and reasons for penalties. We did the same thing for restraint and we found an 86% similarity, which really tells you that SEBI is not thinking of specific reasons that a certain sanction should be imposed and shouldn't be imposed.
Should this go to the higher courts in appeal? Is there something broadly in the constitutional setup that requires regulators to, provide certain reasons or provide a rationale when it is imposing these sanctions? So it's one thing to say that the SEBI Act is silent. And sure, maybe that gives SEBI some leeway to not do a very thorough job of explaining why they are doing what they are doing. But can one sort of argue that maybe if this got appealed, then from a constitutional lens, there would be a problem?
Absolutely. And SEBI is really opening itself up to challenges when it's not providing adequate reasons, right? The court can always strike down that order saying that there hasn't been an application of mind by SEBI or that they haven't taken into considerations issues of proportionality. So it is opening itself up to some risk.
Right. So, it just seems like this is a big can of worms, if I may call it that there are these sanctions that get imposed. These sanctions can have enormous consequences for people on whom they are imposed. And yet we often don't realize or don't see why a particular number was chosen, right? So why 2 years and why 3 years? And sometimes why not anything? And so it's great that this research is bringing out these facts to the public domain, and hopefully we'll see that this leads to some conversation around improving how the parent legislation provides guidance to SEBI to do these things in a more rational manner, in a manner where more explanations are given. So I'm so glad that this research is bringing out these kinds of facts, and I think it's an important part of what we here at TrustBridge do. And one of the takeaways for me from this work was that what we need is also guidance at two levels. One is we need an amendment to the SEBI Act, where just like you have 15J, you need to have, the Act needs to lay out the process or the guardrails before, for SEBI to look up to and say, this is how I impose a specific sanction and this is how I don't do it. But more importantly, there need to be more guidelines and manuals for the SEBI officers themselves on how some of these things need to be done. I feel often that we are working in a vacuum where we kind of say something in the Act or stay silent in the Act, and then downstream we have all of these consequences. So thank you for bringing that out, and thank you for that work. And if you want to read more about this article, we will be putting up the link in our description box. Thank you for visiting this website, and we hope you keep coming back for more insights based on our work. Thank you very much.
Thank you.